Well, good morning, good afternoon, wherever you may be joining us from today. We are very pleased to be here, and we are going to be discussing some of the big changes that you may have seen in non-compete law. And we're also going to talk a little bit today about what you really know, what you really need to know to protect your business, since we are experiencing a lot of flux in both federal and state law. And what I'd like to do, just by way of introduction, is I'd like to introduce the panelists for you today. I am a partner with the firm's Labor and Employment Practice Group based in our New Jersey office. I focus my practice on advice, counsel, and training our clients, employers on a variety of employment and workplace issues. I also defend employers in New Jersey federal and state courts involving employment litigation. My colleague, Justin Condit, is a partner in the firm's Labor and Employment Practice Group. His practice involves representing employers with regard to the full spectrum of employment claims, with particular focus in the financial services industry. Naomi Galama is an associate in our firm's Labor and Employment Practice Group. She's also based in the New Jersey office. Naomi is a recent graduate of Rutgers Law School, where she was heavily involved in the school's Labor and Employment Law Society. My colleague, Matthew Penfield, is a partner in the firm's Labor and Employment Practice Group. In addition to advising clients on a wide variety of employment matters, he specializes in non-compete and trade secret litigation. He is regularly in front of state court, federal court, and arbitration panels on those issues. And certainly not last, but not least, Christina Zarcone is an associate in the firm's Labor and Employment and Professional Liability Practice Groups. Before entering the legal field, Christina served as the Executive Vice President and Chief Contract Negotiator for the Parsippany Troy Hills Education Association. We have three very exciting panels for you today. Our first panel, we are going to be discussing the FTC's new proposed rulemaking that would prohibit non-compete agreements. Our second panel will discuss New Jersey's proposed legislation that would limit non-compete agreements, and they will also provide some updates from other states across the country. And finally, our third panel is going to provide some practical guidance and application on how to protect your business in light of these new developments. Now, along the way, we will be providing 2 CLE codes that will be required for completing your request for CLE credit. So we will be providing those to you. You should have received the CLE request form, but we will be sending out to participants another copy of that form after the presentation today, our webinar. Finally, please feel free to drop any questions into the Q&A function button at the bottom of your screen. This will help us review any questions that you may have along the way. And if we have time at the end of the webinar today, we will try to answer some of those questions for you. Okay, so I'd like to just jump right into our first panel. I'm very excited to be presenting on this topic to you with my colleague, Naomi. And I'm going to have Naomi, we're going to be discussing the Federal Trade Commission's new proposed rulemaking. So I'm going to have Naomi kick us off, and she's going to provide some of the background of restrictive covenants.
Thank you, Emily, and hello, everyone. Thank you for joining us today. So before we dive into the details of the proposed rule, I'm going to start off by giving just a brief overview about restrictive covenants in general. So restrictive covenants are agreements that employers use to protect their business, and they could take shape in different ways. So they can be used as confidentiality agreements, which are used to protect an employer's confidential information and trade secrets. They can be used as non-compete agreements, which I'll discuss in more detail in the next slide. And they can also be used as non-solicitation agreements, which are used to prevent a worker from taking clients and customers to their new employer. The purpose of non-compete agreements, of course, that's of importance today. is to not only protect an employer's confidential information and trade secrets, but to make sure that a former worker doesn't use that information to start their own business or to go work for a competitor. The use of these agreements is crucial because if an employer's confidential information is exposed, it could potentially drive them out of their respective market or industry. So non-compete agreements, they typically have these three essential terms. The length of the time that the employee is bound to the non-compete agreement, the geographic location that the employee may work in post-employment, and the market in which they may work in. It's important that all of these terms are narrowly construed because if the court finds them overbroad or vague, then the court may not enforce the agreement. It's also important for employers to take time to identify the interests that they're trying to protect. And typically, the interests that are used in these agreements are protecting valuable confidential business information, substantial relationships with specific prospective and existing customers or clients, client goodwill associated with an ongoing business, and specialized training. As I stated before, it's so important for these terms to be narrowly drafted because you don't want the interest to be overbroad in which the court may find the term or clause unenforceable. So in the event that an agreement is overbroad or vague, the court doesn't automatically find that the agreement is void. Usually it will see if it could add reasonable terms to the agreement. And typically those terms limit the geographical or temporal scope of the agreement. But of course, you don't want to give the court the power to define the terms that you want for your agreement. So it's really important that you take the time to make sure that the non-compete is narrowly construed so that it can withstand judicial scrutiny. So as you can see, restricted covenants are very important for employers in protecting their businesses. And the use of these agreements is prevalent in several industries, including media, financial services, life sciences, corporate management, and manufacturing. And now I'm going to hand it back to Emily to discuss the details of the proposed rule.
Thank you, Naomi. So the Federal Trade Commission is a federal agency, right? And it's empowered, and its mission statement is to prevent unfair trade, unfair competition, deceptive practices affecting commerce, okay? So back in July 2021, President Biden issued an executive order, and he made it very clear that he wanted to promote competition in the American economy. And he talked a little bit about banning non-competes, and the purpose was for workers to have an easier time changing jobs. President Biden believes that, by prohibiting non-competes, it'll help raise wages, and it will actually improve the economy, okay? And he asked that the FTC would take this executive order and issue some proposed rulemaking. So in January 5th, Happy New Year, we all found this press release and the notice of proposed rulemaking. And the FTC made clear that its position is that non-compete agreements are exploitative. The FTC in its rulemaking in the press release made clear that it's the agency's belief that non-competes suppress wages, hinder technological innovation, and it limits the ability for workers to freely change jobs. And ultimately, the FTC in its press release stated that all of this would be in violation of Section 5 of the Federal Trade Commission Act. So what are the essential terms of this proposed rule? Well, the FTC in its proposed rulemaking would find that it would be an unlawful employment practice for any employer to enter into or attempt to enter into a non-compete with a worker. The proposed rulemaking would also find it to be an unlawful employment practice to maintain a non-compete with a worker. That's where the retroactivity, the rescission, and the notice will come in, and we'll talk about that in a minute. And finally, it would also be unlawful for an employer to represent to an employer that they are subject to a non-compete. Okay, so one of the biggest questions we've been getting with regard to this proposed rulemaking is the retroactivity. And I think it's a valid concern. Most employers, most of our clients are really concerned about how it's going to affect the current existing non-compete agreements. So section 910.2b of the proposed rule would provide that that employers must rescind all current non-competes. Now, the proposed rulemaking talks about a compliance date of 180 days after publication of the final rule. We know that as of right now, this is to be determined. We don't know when a final rule is going to be published, and we're going to talk a little bit more later on about our crystal ball and our predictions. But yeah, I mean, employers are going to have to, under this proposed rule, if it is, if this does make it into the final rule, employers will have to rescind all current non-competes. Now, once they rescind them, part and parcel of this is providing notice to employees. And the proposed rule would provide employers with about 45 days to do that. And they would have to notify employees individually delivered, okay? Now it can be on paper, it can be digitally. And, the FTC has issued a model notice that employers can use, can customize, et cetera. Again, if this proposed rule becomes final. And then it's also important to note that the rescission will not specifically affect other terms of an individual's employment agreement. Another huge question we've been getting about this proposed rulemaking is, does this apply to me? Unfortunately, for most businesses in the United States, the answer is going to be yes. It is very broadly defined. There are some exclusions and exemptions, and we're going to talk about that in a minute. But it would apply essentially to any, I have the definition there on the slide, but essentially it would apply to any person, partnership, corporation, anyone that employs or retains employees, interns, volunteers. What's interesting is that there is this unpaid component. So the FTC is really not concerned about whether the worker is paid or unpaid. And interestingly, we have independent contractors on this list. Most of you already know, most state law has already found that it is inconsistent for an independent contractor to be bound by a restrictive covenant. And my colleagues, Justin and Christy, are going to talk a little bit more later about the current landscape of New Jersey and other states' law. All right, so the proposed rule does provide us with a list of excluded employers that would not be subject to the proposed rulemaking. That would be banks, savings and loan institution, federal credit unions, common carriers, foreign air carriers, any business that's subject to the Packers and Stockyards Act. And it's not on the slide, but the proposed rule also talks about excluding any entity that's not subject to the FTC. All right, so we've also been getting a lot of questions about the sale of business exemption. And, this is a little tiny nugget carrot that the FTC has included in their proposed rulemaking. And this makes sense, right? Because if a seller of a business is selling the goodwill, the clients, their ownership interest, all the quote unquote protectable interest, there should be some assurances that that seller is not going to set up shop right next to the new buyer and actively compete with that buyer. So there is a narrow sale of business carve out. This is between a seller and a buyer of a business. But you'll see here on the slide that the proposed rulemaking talks in terms of a 25% ownership interest. And when we talk at the end of our panel in a few minutes just about our crystal ball predictions, I will note that the FTC we are still in the notice and comment period. And the FTC is very interested in whether that 25% ownership interest should be increased or decreased. Okay, and finally, before I pass it over back to Naomi, who's going to talk a little bit about conflicts of state law, and she's going to talk a little bit about the proposed rules, functional test, and de facto provisions.
Mm-hmm. Yes, so if this rule is finalized, it will supersede all state law regulations that aren't consistent with the rules requirements. This is huge because traditionally states typically control the power of defining what restrictive covenants are enforceable and the requirements that each type must have. So it's, this is a really, big thing that the FTC is doing. And although states will still have power to, have their requirements for restrictive covenants within their states, it would have to offer greater protections than the FTC's rule. Okay, so once again, if the rule is finalized, it would apply to any contractual clause that would prevent a worker from seeking or accepting employment after they separate from their employer. So to determine if the contractual clause would be prohibited under the proposed rule, the FTC plans to use this functional test. And the way the test works is that, you would read a clause, and if it has the effect of preventing a worker from seeking or accepting employment after they leave their former employer, then the clause would be prohibited. So it's important to focus, the focus isn't on the intent or the purpose of the clause, but more so just about the effect of it. So the FTC has stated that this rule is not supposed to apply to other restrictive covenants, such as non-disclosure agreements or non-solicitation agreements, unless such agreements would be so broad that it would function as a non-compete. So here we have some examples of what a de facto non-compete clause would look like. So if a non-disclosure agreement is so broad that it would prevent a worker from working within the same field as their former employer, that agreement would be prohibited under the proposed rule. Another thing to look out for are terms that require a worker to repay their former employer for training costs, and the cost isn't reasonably related to the cost that the employer incurred for training the employee. Terms like that, along with liquidated damages provisions, would be deemed prohibited under the proposed rule. So now I'm going to focus on non-solicitation agreements because that's another type of restrictive covenant that employers heavily use. So as I stated before, the FTC says that the proposed rule wouldn't apply to non-solicitation agreements unless the agreement was so overbroad that it would function as a non-compete. And the reason why the FTC initially says that the rule shouldn't apply to non-solicitation is because the purpose of a non-solicitation clause isn't to prevent a worker from accepting employment. More so, it's about, just protecting their clients and their customers. So examples of a non-solicitation agreement that would function as a non-compete would be an agreement that would prevent an employee from working with their former clients or customer for an indefinite time or sometime in the future. It could also be a worker not being able to hire a former coworker of theirs. And now I'm going to kick it back to Emily to discuss some of the predictions for the proposed rule.
Great. Thank you, Naomi. I mean, I have, honestly, most of the questions we've been getting is, what do you think is going to happen? And so I want to spend the time that we have left for our first panel trying to share with you some of our predictions, what we think is going to happen. We're going to use our crystal ball and see what we can find. Look, under current law, non-compete agreements, I mean, this is a function of state law and state case law. Some states have statutes, some operate under case law. Chrissy and Justin are going to talk about that next. So historically, the FTC and the federal government has never really got involved in non-compete agreements before. And most of the commentators that we've seen, including myself, question whether or not Section 5 of the FTC Act really empowers the agency to impose this kind of overbroad nationwide rule. And what's really interesting is when you look at Christine Wilson, one of the commissioners on the FTC, her prediction is that, and her statement was that this rulemaking is likely going to result in protracted litigation, and she believes that the FTC will not prevail. Now, that's Ms. Wilson. She cites to the major question doctrine, and whether or not the commission has the authority to engage in this kind of nationwide rulemaking. Now, you may remember the major questions doctrine, because this is what the Supreme Court used with regard to the litigation of enforcement of OSHA's COVID-19 vaccine mandate. Okay, so I'm going to close out our first panel this afternoon with basically what we see as the next steps and where we see this FTC proposed rulemaking go. So, as I mentioned earlier, the public comments will end on March 20th. And, this leaves us with a lot of questions. Will the content of this proposed rule change? And, on this slide, I have, our alternatives being considered. Absolutely. The FTC is considering alternatives, and they're soliciting comments and responses to a lot of different alternatives that are posed. Now, this proposed rulemaking is several hundred pages, and there are an enormous amount of questions posed, alternatives being considered. I would be happy to share those materials with you if you have certain, specific questions about the types of comments that are being asked. But I mean, essentially, some of the big ones are whether franchisees should be covered, whether certain categories of employers should be considered differently, whether there should be a rebuttable presumption instead of a ban for senior executives. And again, I mentioned this before about whether or not the sale of business, the ownership percentage should be higher or lower. So what do we think is going to happen? Your guess is as good as ours. We think that there will be a final rule. There will absolutely be a final rule of some form. We believe and we expect that there is going to be a lot of legal challenges to the final rule, which is going to probably go the way of the COVID-19 mandate. But again, we don't know how this is going to turn out. They could issue a proposed rule that has changes in it. And frankly, we just don't know how long that's going to take. And after that, once there's a final rule published, then the effective date would be 60 days after that. And then finally, with regard to retroactivity, rescission notice, employers would have another 180 days after that for compliance. So, I think Naomi and I have had a really great time kind of highlighting and going through this proposed rulemaking. I mean, your guess is as good as mine as to how this is going to turn out and how things are going to be changed in the final rule. I think really the takeaways for us with regard to this is that it's really just to try to stay current and just stay updated with what's going on. And I think there's plenty of time to prepare. So we'll see how it goes. Okay, so now it is my job to give you our first CLE code, which will be protect. The first CLE code is protect. And now I'm going to pass it over to Justin and Chrissy, and they're going to talk about New Jersey's proposed legislation and some other state developments in state law.
Thanks, Emily. So our focus today will be on New Jersey's new proposed law. But before we begin, it's just very important to note for employers that they should be paying attention to all changes in every state in which they have employees. And before Chrissy talks to you about the proposed new law in New Jersey, I'll quickly go over kind of the current landscape of restrictive covenant agreements in New Jersey. As many of you probably already know, there's currently no statute that governs the enforceability of restrictive covenants. The restrictive covenants are enforceable if they are reasonable and further a legitimate goal. And you'll see there on the slide the test for reasonableness. One other important point that we want to note is currently courts are allowed to limit or blue pencil a restrictive covenant that may be overbroad. And we'll get into why that's important a little bit later. Okay, now I'll pass it over to Chrissy.
Thanks, Justin. So New Jersey is one of the myriad of states that's considering this type of legislation that's going to limit the scope and enforceability of restrictive covenants. Now, it's important to remember that some states are going to draft legislation that might completely outlaw restrictive covenants. That's not the case with New Jersey. Restrictive covenants will still be potentially valid and enforceable, but only if they meet this new set of criteria that's been outlined under the pending legislation. And the one thing I want to point out before we kind of dive into the specifics of the new legislation and its criteria is remembering that under the current system of assessing the reasonableness of restrictive covenants and non-competes under the common law system, it boils down to if the court deems the restrictive covenant reasonable, it's almost definitely going to therefore be enforceable. Under the pending legislation, the New Jersey state legislature has outlined the criteria that must be contained within the non-compete agreement in order for it to be deemed valid. However, that is not the end of the road. Just because the restrictive covenant or non-compete agreement is valid, it doesn't necessarily mean it's going to be enforceable under this new system. So let's take a look at why by diving into the specific criteria that are now requirements for all restrictive covenants if this new legislation is passed. So first, the restrictive covenant must be in writing. It has to be signed by both parties, and it has to state unambiguously the employee's right to seek counsel before signing and agreeing to the non-compete clause. Whereas before, all restrictive covenants had to be narrow in scope. They couldn't be any broader than was necessary to protect the employer's legitimate interest. As Justin mentioned, we're now codifying what that narrow scope looks like. So when you look at the temporal and geographic scope of these non-compete agreements, whereas before the courts assessed what was reasonable and what wasn't, under the new bill, 12 months is the maximum that the non-compete agreement can apply. That's your temporal scope max. Geographic limitations are not as specifically outlined, but there's an interesting new shift. Whereas before, the geographic scope was outlined according to the employer's interest, where they had clients, where their place of business was. Now, the geographic scope is limited according to the services that the employee provided. For the last 2 years, they worked for the employer, and it's limited in scope to only the areas that specific employee actually serviced clients on behalf of the employer. So we see that significant shift. The remaining criteria under the bill mostly deal with how New Jersey is trying to ensure that its legislation is applied when it comes to these restrictive covenants. So you can't penalize an employee for challenging the enforceability of the covenant. Employers can't include a workaround choice of law provision that's going to circumvent New Jersey's requirements and apply, let's say, New York law. You have to apply New Jersey law to restrictive covenants and non-compete agreements under this bill. And you can't, of course, force your employee to waive their rights under this bill in the restrictive covenant itself. Some of the remaining criteria are catch-all provisions to ensure that the overall agreement is not unduly burdensome or inconsistent with public policy. This has always been a touchstone of reasonableness and enforceability when it comes to restrictive covenants. But the last criteria is interesting in that an employer cannot now restrict an employee for providing services for one of the employer's clients, so long as the employee does not actually solicit or initiate that client contact. So here's an example of what I had mentioned a few minutes ago, which is you can have a very specifically tailored non-compete agreement that is reasonable and valid according to the new bill, but might be unenforceable because a former client or a client solicits your former employee, and therefore you can't now enforce the restrictive covenant. Now I'm going to turn it back to Justin to talk about some of the other interesting criteria under this new bill.
Thanks, Chrissy. So in addition to those criteria, there are other very important provisions that employers need to be aware of. And they're listed on the slide, but we'll quickly go through them. The first one is restrictive covenants will be unenforceable against certain categories of employees. That would include students, temporary employees, independent contractors, low-wage employees, and employees under the age of 18. The new bill would also make restrictive covenants unenforceable against employees of less than 1 year. So if you have an employee who has only been working for you for 6 months, you could not enforce that restrictive covenant against them. The new bill would prohibit employers from restricting an employee from working with an employer's customers. And Chrissy just mentioned that, but in that situation, it would only be if the employee does not initiate the contact. And the next one might be the most important provision to many employers, but the new bill requires employers to pay employees 100% of compensation during the restrictive period. So if you are going to require an employee to not compete for 12 months, they will get a full salary and compensation during those 12 months. And finally, and I alluded to this before during my opening, but the new bill would eliminate a court's ability to blue pencil agreements. So as of now, a court could blue pencil an overbroad restrictive covenant. Under the new bill, the court would not be able to do that, and the whole agreement or the whole restrictive covenant would be deemed unenforceable. And now Chrissy will go over some of the notice requirements and finish off the slide.
Thank you, Justin. So as I mentioned before, and I'm going to keep hitting this point pretty hard, is that if you meet the criteria and your non-compete agreement is valid, it may not be enforceable. And then the notice requirements and provisions is an area that I think really showcases this. So there are a ton of notice requirements that are included in this bill. So let's say that you have a valid non-compete agreement, it meets all the criteria. You have to make sure that you post the non-compete agreement and the criteria somewhere prominently in your place of business. When you hire a new employee, you have to provide them with a written copy of the non-compete agreement, either 30 days prior to them starting their work for you, or at the time that you offer them employment, whichever is earlier. So again, if you offer somebody employment 40 days before they start, and you do not remember to include that non-compete agreement just because you provide them notice 30 days before they start, that agreement is now void. So you can see the difficulty that employers may face with these notice requirements. And some of the other provisions are that the statute provides for a 2-year statute of limitations, and courts are allowed to award damages for lost compensation, attorney's fees, any costs to the former employee, and liquidated damages up to $10,000. Now, a key difference between this and the FTC rule is that in New Jersey, if this legislation is enacted, it will be in effect immediately, but it will not be retroactive. So any restrictive covenants that are reasonable that you have for current employees will still be valid. However, you may update them with your current employees to ensure that they are enforceable and in line with the new legislation. And now we're going to look at some interesting hypotheticals. Justin and I have polled holdings from recent cases in New Jersey that deal with non-compete agreements, specifically case holdings that speak to the reasonableness of these non-compete agreements. And we want to look at whether under the pending legislation, these holdings would hold up. So let's take a look at protected goals versus Torero. Here, the court held that a non-compete was enforceable because it was drawn narrowly by applying only to the employer's current and potential clients. So we would like to know, would this agreement be valid under the new law? And you have a poll to that effect right in front of you. So you take a second and answer the poll, and we'll see what results we get. Okay, so before the results for the poll necessarily come in, I want to talk a little bit about, thinking about that enforceability factor, right? Like just because the agreement is valid, we have to look at whether or not we're going to be able to therefore enforce it. So always be thinking about that.
I think we can see what the results are.
Let's pull them up.
So
So we have a pretty even split with this, which is interesting. So Justin, what do you think? Is this agreement valid under the new law? Yes, no, maybe?
So I will admit we started with somewhat of a trick question. So the answer we have is maybe, and that's because under the new law, an employer could not restrict the employee from working with clients, provided that the employee did not initiate that contact. So yeah, mixed results, and I expected that here because of the maybe answer.
Well, you got the question correct, Justin. So you should be very proud of yourself. Let's take a look at some other ones.
So I'll go over the holding for this one. In this case, the court held that a non-compete restricting a physician from practicing within a 12-mile radius of the employer's office for 2 years after his termination was enforceable. So again, would this agreement be valid under the new law? And I'm hoping this one is a little easier than the first one. Few more seconds, and we'll check the results. Okay, so it looks like a large majority said no. Christy, what do you think?
You did give me an easier one than I gave you, Justin. The answer is no, because this two-year limitation is outside of the temporal scope, which is now limited at 12 months. Okay, one more hypothetical before moving on. So this court held that a non-compete was enforceable, but it required a reduced geographic scope than the one that was outlined in the actual non-compete agreement. So would this agreement be valid under the new law? Couple more seconds. Okay, what do we have as far as results? Ooh,
Pretty mixed results to this one.
yeah.
Too.
What do you think, Justin?
So this one would be no, and the reason is in this case the court blue penciled the agreement, and blue penciling would not be allowed under the new law. So if the restrictive covenant was unreasonable or overly broad, it would be deemed invalid and unenforceable, and it could not be blue penciled by the court.
Correct. And I think it's interesting to point out that Naomi had mentioned how you want to be very meticulous in drafting your non-compete agreements so that a court doesn't come in and blue pencil them. And that's absolutely true. You want to actually draw your own parameters in these situations. However, look at a state like New Jersey, where when they eliminate the blue pencil rule, it's all or nothing. So you wind up walking away with a completely voided agreement. So always keep that in mind as well.
Okay, so I'm going to quickly go through a few states that actually have enacted new laws prohibiting or limiting non-compete agreements. First, California. In California, non-competes are prohibited. The language from the statute is there, and I'll quickly read it. It's every contract by which anyone is restrained from engaging in lawful profession, trade, or business of any kind is to that extent void. Colorado has not prohibited non-compete and non-solicit agreements altogether like California, but it has limited them to certain in certain contexts, and it's during the sale of a business and for highly compensated workers. So any non-compete outside of those two examples would be not enforceable in Colorado. And then lastly, Illinois, they prohibit non-compete agreements for both non-compete and non-solicit agreements for employees earning under a certain threshold. So it's $75,000 per year for non-compete agreements and $45,000 per year for non-solicit agreements. And then Illinois also requires that these agreements be supported by adequate consideration. And then they go on to define what that term means. And we provided that for you on the slide. So next we have a couple more hypotheticals, and we'll go through these pretty quickly, but here's a scenario. A New Jersey-based employer is hiring a remote worker who lives in California. Would the New Jersey employer's non-compete be enforceable against this remote employee in California? And then a separate question, it looks like you might have to answer both polls at once, but a second follow-up question is, what if the remote worker lived in Colorado? Same question, but different state. So since we are running close to time, we'll give you a few more seconds and then we'll move ahead. Okay, so the first one, it looks like is no, and then the second one, it looks like we have more of a mixed bag of answers. So Chrissy, in response to number one about the California employee.
I think the overwhelming majority is correct. This is a violation of California law, which prohibits all restrictive covenants. So,
and now explain for the participant or for the viewers, I guess, why Colorado is different.
Okay, so Colorado, I think the answer I think is going to be maybe, because it's going to depend, right? Is the remote worker a highly compensated employee? So you'd have to do an individual analysis to figure that out. So right now, we wouldn't be able to tell.
Great. Okay, now we're going to pass it on to Matthew, who's going to go over some practical applications of restrictive covenants.
Thanks, Justin. Great job, everybody. I want to take a few minutes and talk about practical applications, how to protect your business, or key takeaways of what you can do. And these are also going to be provided to you in the context of what is it that you need to do to best prepare to protect, but also what is it that you need to do to best to prepare for any potential litigation regarding former employees and the enforcement of restrictive covenants. I have had a chance to look at some of the questions in the Q&A, and I'm going to try to address some of those as I go through my presentation that you've put in there. I will tell you, anything we don't get to, we'll try to reach out to you when the webinar is through and answer your questions. And of course, you can reach out to any one of us with your questions about this. So you've heard about the legal landscape, the FTC, the New Jersey law, the different state laws. Well, what is it that employers are doing, or what is it they can do to protect confidential information, protect employees, and protect customers? So one thing that we're seeing is a movement by states that Justin and Chrissy just went through, and now the FTC on the federal government side, to restrict or to greatly limit non-compete agreements. And some of those are what we would call pure non-compete agreements. In other words, you can't go work for a competitor. You cannot perform that job at all. And some of these restrictions, particularly in the state realm, are more about different types of restrictive covenants that aren't pure non-competes. In other words, a non-solicitation of customers provision, which has some different rules that applies, non-disclosure agreements, and then non-recruitment agreements, which have also come under great scrutiny by the federal government. Someone posted one of the questions about would these various restrictions apply to the non-recruitment or non-solicitation of employees, and those have been of heightened concern in the last 4 or 5 years. And in fact, the Department of Justice has undergone a lot of investigations and in fact settlements with employers that have agreed to what we call no poach agreements. I won't hire your employees if you don't hire my employees. If you have a question about those specifically, contact us, because right now the DOJ is very concerned about those and believes that from an antitrust standpoint, those violate federal law. So contact us about those. There are some small areas where you can possibly still have one of those in place. But at the same time that we're seeing this movement with the federal government and with the various state governments on these different agreements in place, we're seeing and employers are facing significant labor challenges. We know you as employers are facing that. And with recent labor shortages, one of the things that we're seeing, in fact, is that employers are actually adding non-compete, non-solicit, non-disclosure clauses into their agreements, and they're taking action to enforce those to try to protect their employment base. Well, that's the polar opposite of what's happening with what the FTC is attempting to do, with what some states are attempting to do to ban non-competes outright. And when we see those polar opposites begin to clash with one another, you can expect what happens: litigation. We're going to have litigation over these things. We're going to have litigation over whatever rule, if a final rule is issued with regard to the FTC. And I will note that someone, I think, posted this in the comments or the Q&A. The comment period for the FTC was actually extended this week. It actually falls, I think, the 3rd week of April before they'll then take all those under consideration. But we're going to see.
Thank you, Matthew. I was going to jump in and say that that it was extended to April 19th.
Not the 19th. The 19th. Yeah. Thanks, Emily. But we're going to see litigation over that. And if you listened to, for example, the Supreme Court's arguments last week on student loans, and you hear what the current court is facing and struggling with about what Congress can pass on to these agencies, we know there's going to be a lot of litigation over this rule in whatever it comes forward. We also know that there's a lot of litigation over enforcement of non-competes, non-solicits, and confidentiality provisions with employees. And some of the movement by states in the FTC have actually emboldened employees to challenge those agreements. And we also know that in that litigation, there's really 2 questions that courts ask. One of the things that Justin said a few minutes ago in response to one of those questions is, what's the right answer? And Justin said, well, is it enforceable? What did he say? Maybe. And when you actually get into litigation over these, that is often the answer, because what courts are dealing with is both the legal aspects. In other words, is the clause in and of itself valid and enforceable on its face? But also, because you're seeking an injunction, the court is also considering the equities. What is the equitable response to this situation? Should I actually enter an injunction or not? And many times that answer is, will they enter one? Maybe. So what can you do to put yourself in the best position as an employer to be ready for that? Well, here's some key takeaways. You need to stay up on whatever the current legislation is in the various states in which you have employees. We know that's a lot to ask. So we try to do that for you. We try to send out alerts, but we know there's a lot of movement right now, but employers have to keep track of that and know what the current law is, but also what is potentially coming down the pipeline. You also need to look at your own restrictive covenants. Are they valid? Are they enforceable under the state laws? in which you currently have employees. You also need to think about, if they're not, are there changes that we need to make? And we'll talk about a few of those in a minute. In fact, there was one of the questions that was posed regarding if there ends up being a ban on non-competes, whether it be from the FTC side or whether it be in the various states in which you have employees, what does that mean for some of the other provisions that I have? And I think that means if there's a ban on non-competes, or if you have employees in states where they don't allow non-competes, you really need to look at what the non-solicitation language is in your agreements. And really is important is you need to look at the language of what your confidentiality provisions are. What does it say? Does it say abroad, you can't use our confidential information, or does it go as far as explicitly stating what you can't use and how you can't use it? And I think that's going to be very important. And it's probably going to be the next line of litigation in those jurisdictions in which non-competes are actually banned and you can't use them. You also need to review not only the agreements, but the protocols and practices that you have in place as to how you treat confidential information. So what is it that you need to do with this? Well, you need to look at who is it that you're asking to sign a restrictive covenant? Who signs it? How does that impact whether the restriction is narrowly tailored or not to a specific employee or a specific group of employees? One argument that we regularly hear on the enforcement side is that a former employee will argue that restriction is overly broad. That's an overly broad protection because you apply it to everyone in the workforce. And the argument goes something like this. Employers have to show a protectable interest in order to enforce restrictive covenants. The employer makes all employees sign one of these agreements, even those who may or may not have access to confidential information, even those who may or may not use it in their job. And that means, as the argument comes from the former employee, that means that the information is not really a legitimate protectable interest, and therefore you can't enforce this restrictive covenant against me. Now, the counter argument to that is not surprising, and we say the employer is not here enforcing this agreement against everyone in the workforce, even against everyone on their payroll. We are here to enforce this agreement against this one former employee, and the question is whether that employee had access to and used confidential information, and whether they could use it to harm you if they're employed by a competitor or if they solicit your customers. Now, courts generally understand that, but when you're looking at the equities involved, the court's also going to be swayed by that argument. And so you need to think about who is it that you require to sign these agreements? Is it everybody, or is it a narrowly tailored group? Now, when you look at your agreements, you're also going to have to look at the scope of all the different restrictions. So we've covered many of these. How long is it? Is it 12? Is it 18? Is it 24 months in duration of what I can cover? What about the geographic area? Is it within a certain area? Is it not? In the state in which I have employees, is there something in the law that says I don't have to have a geographic area as long as I fully define customers at issue? So what are those customers at issue? How do I define them to protect them? Is it only those customers with whom that employee gained or confidential information? Is it only those customers with whom that employee had contact or significant contact? Those are all questions that go into the review of and the potential revisions of those restrictive covenants. But you also have to look at not only the time and the geography and the customers, you have to look at what the actual activity is that you're trying to restrict. What is the scope of that activity? What do you need to protect? And what does your agreement actually say? Does it say the former employee agrees that he or she will not work for a competitor? And is it that broad? Well, do you define competitor? Do you define the competitive industry? All of those are questions that you're going to have to answer to a court in the event that you're seeking enforcement. Well, what if the agreement goes a little bit further and it says, okay, you agree not to work for a competitor in a similar role? Well, how well do you actually define that role in your agreement? You're going to have to look at that as well. Now, when you actually decide that you're going to seek enforcement. And I think this is the next slide, Christy. When you're going to seek enforcement, you have to consider where you're going to seek enforcement. And we've covered part of this already. The questions are, what law applies? Do I file in state court? Do I file in federal court? Do I have an arbitration provision or not? Well, why is that important? Because regardless of the law that you choose and put in your actual agreement, a court that is enforcing that agreement is going to look at that law and they're going to ask this question: is that law, is that state's law that you've included contrary to the public policy of this particular state? And if they think that it is, they are going to apply their own state's laws. So it's not as simple as choosing a choice of law provision in your contract and saying, well, I know that our agreement is enforceable under this state's law. You have to look at where you're going to seek enforcement. You also, if you decide to move forward, you have to think about, what court am I going to file in? Is it federal court? Is it state court? What are the procedures in place for each one of those? How quickly can I get in front of a judge to make a determination? What are the processes that I'm going to have to put forward? What is the burden of proof or the standard in each one of those courts? All of those are questions you have to think about when you seek enforcement. What if your agreements have an arbitration provision? Well, do they have a carve out for injunctive relief? Is that written into the agreement itself? And then with the forum in which you've chosen, is there an opportunity to obtain temporary preliminary injunctive relief? Now, some of you, as we've seen by the registrations for today, live in the financial services industry. And there are specific rules about where you have to bring claims. If you have registered representatives as employees and you're a broker dealer, well, we all know that those claims are subject to arbitration before FINRA, the Financial Industry Regulatory Authority. That's where the ultimate merits are going to have to be decided. But even within that forum, there is a rule in place to actually obtain temporary injunctive relief from a court. And you can go obtain that relief, and if it's granted, you're going to receive your hearing in FINRA on an expedited basis when you're seeking a permanent injunction. Well, what if your employment agreement or your restrictive covenant agreement doesn't call for a specific forum? Well, where are you going to end up if you have arbitration? Is it AAA? Is it JAMS? Is it some other forum? You have to look and see, is that forum going to allow me to seek the relief that I need? So just very briefly here at the end, the takeaways on what steps should I do when an employee leaves. Well, the first thing that you do, and it's not on the bullet point, but the first thing that you do is you call us or you call your outside counsel. You need to strategize on how best to move forward, because you're going to have to review the agreements. You're going to have to make sure that they are valid and enforceable. And when I say review the agreements, it's not only the restrictive covenants in an employment agreement. Do you have a confidentiality agreement, a non-disclosure agreement, any other handbook acknowledgement or policies in place? You're going to have to review the activity. You're going to have to contact IT and say, what is it that this employee did when they were preparing to leave? And do we have any concerns about that? And you're going to have to start gathering that evidence. You're going to need to monitor post-employment activity. What does that mean? Well, follow social media, look at your competitor sites and see if that employee, if they truly has a non-compete, see if that employee shows up at one of those competitors. Now, regardless of whether they show up at what competitor, regardless of whether you think they've done something wrong, you should remind them as a best practice, remind them of their obligations, send out that letter as soon as they leave, and then you watch to see what happens. Now, if there's something that is happening, or you think you do need to seek enforcement of your restrictive covenants, then you begin to ask the question, where do I file? When do I file? And against whom do I file? Do I include their new employer or not? Do I file this in state or federal court? What state am I going to have to file in? When am I going to file? And this is the last point that's important, because this really is a balancing test. You can't run into court too soon when you haven't developed sufficient evidence to obtain an injunction, or else you're going to be in serious trouble. But at the same time, you don't want to run in when you don't have that, but you can't wait too long as well. So there's a balancing act between when do I go in to get this information. I'm going to offer you the second CLE code right now and see if any of our other panelists have had a chance to look at some of the questions that they can briefly answer in the minute or two that we have left. But the second CLE code is secrets. Second code is secrets. And it looks like we are probably out of time. So I know that there are some questions that are pending in the Q&A. I will tell you that we are going to look at those. We're going to reach out to you with some of specific answers to those. We would also let you know that if you have any questions at all, reach out to us. You have our information. Thank you for your time today. Thank you to all the panelists. We have truly enjoyed presenting this topic for you. We wish you the best going forward. Bye.